Hi everyone, and welcome to week 8 of Common Law 2. We've got a little bit of catching up to do, and we're going to start in this video by talking about Richmond versus Croson to wrap up our discussion of affirmative action. Now, we've already talked about affirmative action in higher education. The critical cases there are the University of Michigan cases. We'll talk a little bit more about that in our live session. But you know from the Michigan case about the University of Michigan Law School, how you design an affirmative action program that will survive strict scrutiny, and then how you litigate a case like that. Your compelling interest is diversity in higher education, and your narrowly tailored means would be trying to reach critical mass by considering somebody's ethnicity, an applicant's ethnicity, a mere plus after an individualized review of each application. We left off last week talking about how that doesn't work, so especially on the compelling interest side of things. That doesn't work when you move over to employment, because here we're talking about people working for the government and contracting for the government. This is often things like construction contracts, where you're not going to have the same arguments available to you, right? That when you think about diversity in higher ed, remember those amicus briefs that we talked about, where generals and admirals and CEOs were saying that we get our leadership out of higher education. And so diversity, God bless you, Lainey. So diversity is a very important, indeed compelling interest in the context of higher education. You're not going to get generals, admirals, and CEOs saying that they're recruiting out of construction companies. And I don't mean to diminish what anybody does, the work the construction companies do. But I mean to say, the same interest is not going to fly. You can't argue that diversity is a compelling interest in a workplace where people, their job is not to interact with other people of different cultures and all that. So, I mean, you could argue that. So let's just put it this way: the Supreme Court has never fought an argument like that. So that brings us to Richmond versus Croson. Richmond versus Croson comes to us from Richmond, Virginia. And in this case, when you look at the statistical disparity, there was obviously a problem here. First of all, if you are familiar with Richmond, Virginia, Richmond is about 50% African American. And when you look at the number of contracts that were being let by the city that were going to minority-owned businesses, it was less than 1%. So there is a huge statistical disparity between the population of the city and the contracts that are being let. As we'll discuss, everybody associated with the business that went on in that city knew why, because there was rampant discrimination going on with regard to the construction industry. So we talked about how remedying a history of past discrimination may in some circumstances be a compelling interest, and we find out in the employment cases, so you're on that side of your grid, right, your affirmative action grid, courts say that actually it is a compelling interest to remedy your own jurisdictions, please remember that, your own jurisdiction's history of discriminating. But we still have this problem of you can't go into court and say and expose your client to limitless liability by saying that your client has been discriminating for so long, and et cetera, et cetera. So we're going to see in this case a way around that. The first thing I want to talk about, though, is lawyering. Every once in a while we run into a case that you can use as an example of how not to be a lawyer. Now, if the city of Richmond wants an affirmative action program, they're going to go to their city attorney and tell the city attorney, draft us an affirmative action program. The city attorney in this case gets to work drafting an affirmative action program. I want to call your attention, when you're looking at the Croson case, to an internal site to a case called Fully Love. So what the lawyer for Richmond does is goes and finds a Supreme Court case, the Supreme Court case is Fully Love, in which the Supreme Court has upheld an affirmative action program. And then the lawyer copies that program, presents it to the City Council of Richmond, and says, give me the gold medal for the Best Lawyer of the Year award. I have drafted for you a foolproof, bulletproof affirmative action program, it will absolutely be upheld by courts. And how do I know this? Because this precise program has been upheld by the Supreme Court already. Congratulate me, pat me on the back. Here's your program, let's go. Well, Richmond gets sued over its program, and they lose. And why? Okay, think about this again. This is the lawyer for the city of Richmond in Virginia. And the problem that the city council is trying to rectify is rampant discrimination against certain ethnic groups and primarily African Americans. And yet Richmond winds up with an affirmative action program that identifies the following ethnic groups as the groups that are going to benefit from the affirmative action program. Right? If you're going to have an affirmative action program for ethnic minority groups, you have to identify, obviously, in your program, which groups qualify. Here's what Richmond's program includes. Citizens of the United States, I'm on page 1484 to 1485, who are blacks, Spanish speaking, okay, stop right there. Spanish speaking. What kind of draftsmanship is that? Spanish speaking qualifies for this program. So you can, our Spanish speakers out there, you can help me out here. Hola, ¿qué tal? ¿Cómo está? ¿Habla inglés? I don't know that I spoke Spanish very well, but I tried, and I'm pretty sure I got a few words out. So under this program, what did I just do? Well, that's right. I qualified myself for Richmond's affirmative action program by speaking Spanish. Pretty bad lawyering. Orientals, the policy continues. Of course, we don't talk about humans that way anymore. That's what we say, Asians. So that word finds its way into the Richmond program. Indians. Here goes Laney. One has to wonder whether by Indians one meant actually people from India, or did you mean Native Americans? And if you meant Native Americans, why didn't you say Native Americans? Okay, so Laney is done with her barking fit. The next one is my favorite. This is Richmond, Virginia. Eskimos. Eskimos is one of the groups that's covered in the Richmond affirmative action program. Everybody knows you can't swing a dead cat in Richmond without hitting an Eskimo. Or Aleuts, which is people from the Aleutian Islands. So, we have an affirmative action program in Richmond to benefit Eskimos, Spanish speakers, whatever that means, Orientals, Indians, and Aleuts. All right. How did we wind up here? So to repeat, the lawyer found a case where the Supreme Court upheld an affirmative action program and copied the program. First of all, it was a really old affirmative action program. That's why you wind up with this kind of language, right? That by 1989, people should have known better that we're not using this anymore. These types of words. Second of all, let's take a look at whose program it was that was upheld in Philadelphia. It was an affirmative action program passed by Congress. Now remember the rule that's been emerging in these cases. If you have a compelling interest in remedying a history of discrimination, it's going to be your own history of discrimination. The United States Congress, of course, has jurisdiction over the entire United States and its territories, including Alaska, right, and places like that. So Congress may have a compelling interest in remedying a history of discrimination against all of those groups. Richmond, on the other hand, does not have a compelling interest in remedying a history of discrimination against Eskimos because Richmond is a city in Virginia where the problem is largely discrimination against African Americans. Now, one more thing about Richmond versus Croson. What you take out of this, your compelling interest in remedying a history of discrimination is limited to your jurisdiction and the history in your jurisdiction. In Richmond versus Croson, the court recognizes that a lawyer cannot go into court and expose his or her own client to limitless liability. So the court says, and I hope you caught this language out of Richmond versus Croson, the court says what you would need to allege to have a compelling interest in one of these cases is passive participation in a history of discrimination. So bookmark that term, passive participation, and we will pick up in a second video to talk about what that means and why it works.